Thank you everyone for joining, and welcome to everyone on this new webinar. So tonight, we are extremely happy to be able to share with you some fundamentals on data protection and updates. But before we do this, let's go through this formally and properly. So let me welcome you first on behalf of the Law School of UCLan Cyprus, the Larnaca and the Famagusta Bar Associations. It's a real pleasure for me to welcome you all this evening to this informative webinar held on the occasion of the World Data Privacy Day, which is actually celebrated every 28th of January. This is the second in a series of continuous professional development or CPD webinars co-organized by the School of Law of UCLan Cyprus, the Larnaca Bar Association and the Famagusta Bar Association. This is done to celebrate the signing of two memoranda of understanding, one between the University and the Larnaca Bar Association and another one between the University and the Famagusta Bar Association. In a nutshell, these two MOUs provide an official framework for the collaboration between the university and the local bar associations. And we basically provide that framework for collaboration in the areas of research, innovation, and applied experience in the broad field of law. So to that intent, this collaboration further facilitates and promotes the dissemination of high-end knowledge and know-how to the members of all three institutions involved, including the students, the researchers, and the legal professionals, of course, so that everybody may enhance their strategic position with regards to law, compliance, ethics and integrity, rule of law and justice, and each of us within our own areas of expertise. These MOUs are further evidence of our long-standing mutual commitment and relationship and can only enrich us all. I mean, we've been working with the local bar associations for a long time, but the MOUs allow to formalize this. Areas of collaboration include the co-organization and mutual support of events, competitions, trainings, internships, and other professional and educational activities, as well as awareness raising, capacity building, and wide dissemination of expert outputs, such as tonight's webinar. To celebrate the signing of these two MOUs, a series of related CPD activities is unfolding in 2022, and tonight's webinar is an outcome of this excellent cooperation. So I would like to thank the Larnaca and the Famagusta Bar Associations for their trust and also for their willingness to work with us. Let me now turn to our speakers and thank our distinguished speakers, both very fine legal practitioners, for their willingness and enthusiasm to speak to us tonight, despite their busy schedules. Of course, I would like to thank all of you, the participants, as well as the colleagues who have worked on today's event across all institutions. It's a pleasure and honor to be able to engage with so many participants to this webinar, including students, academics, professionals, and members of the wider public. Before I continue, please be reminded of the slide that was projected just before, that this webinar is recorded for the purpose of widening access to educational resources, and that you have been asked to consent to this. So I would please ask you to keep your cameras and microphones off and use the chat function in the MS Teams classroom to ask questions or make comments. If you do not wish to appear at all on the recordings, then don't use the chat function either. Can I please also remind all that each speaker and other participants will take part into the webinar for educational purposes, and this is an educational setting. That means that each participant, whatever each participant will provide verbally, electronically, or otherwise, must not be accepted or interpreted as either legal advice or any form of advice. You may view materials at your disposal in the MS Teams classroom under the files section, you will see there are materials from the school in particular, which you are free to take away from the webinar and use with the necessary acknowledgements. Subject to the professional background of each attendee, participation may contribute to your informal or formal CPD, continuing professional development, or PD, professional development, or other self-managed learning and development needs in accordance with your own professions. Cyprus registered lawyers have been asked to provide their registration numbers to the Cyprus Bar Association so that we may report their CPD hours for this webinar onto the platform of the Cyprus Bar Association. I would like to remind all Cyprus registered lawyers, however, that they would need to attend most of the webinar to collect the hours. Let me very quickly say a few words about tonight's topic, which is a topic that I think we all cherish, and this is why we are here, data protection, which forms part of the fundamentals in the CPD portfolio of the School of Law in association with legal and other practitioners, including engineer, data protection officers, of course, and so on. Judging by the number of participants tonight, the topic is of ever-growing importance to the legal profession, and this is very good news. Hence the emphasis placed by the Larnaca and the Famagusta Bar Associations on this topic, since they chose it out of our portfolio of CPDs. For the past few years, the School of Law has been organizing knowledge transfer, knowledge exchange events around privacy and data protection on a regular basis in the form of seminars, conferences, public lectures, trainings, or other online activities. Some of them are projected on this slide, as you can see. Every time we have tried to ensure free and open access to educational resources emanating from these events, and most of the events are also free and open access. I therefore invite you to check our website, more specifically the Law Academic part of the UCLan Cyprus website, which you have here on the slide, and also our annual reviews, which you can find on the School of Law's website, so that you can actually identify more resources of relevance to privacy and data protection. But before we give the floor to our speakers, I'm also happy to share with you additional resources of international reach on the topic of smart information systems and human rights, which you will find of much value to your work. Again, in this large EU-funded project that just completed, you will find much focus on privacy and data protection in the present and the future. Turning to tonight's event, I'm very privileged to welcome in order of appearance Mr. Stylianos Christoforou, Managing Partner at Stylianos Christoforou & Co. LLC, with whom we have already run a number of activities with respect to data protection at UCLan Cyprus. You may have seen it on the previous slide, actually. And Ms. Maria Raphael, Director and Shareholder in I. Frangos & Associates LLC, on behalf of the Larnaca and the Famagusta Bar Associations. Their rich bios appear in the flyer that you all received, so I would like to refer you to that rather than enumerate their long list of achievements, not only in Cyprus, but also internationally. So a warm welcome to the two of you, and thank you again for being with us tonight. Now, the primary aim of the webinar is to provide participants with information and insights into recent developments in data protection regulation in Cyprus, the EU, and internationally. We try to do this once a year and identify the most recent developments and the most important ones for the legal profession. The webinar format provides opportunities for participants to engage in discussions with the panelists about current issues in data protection regulation and practical approaches for addressing the issues arising from these matters through the chat, but also during the Q&A session at the end. So our speakers will touch upon recent legal developments in data protection, including analysis of data protection authority enforcement actions, regulation and court decisions, international data transfers, and how the COVID-19 pandemic has affected the enterprises and the obligation for adequate data protection in their speeches. Let me therefore turn to our first speaker tonight, Mr. Stylianos Christoforou, with his speech entitled Analysis on the Spirit of the Decisions of the Commissioner for the Protection of Personal Data. Stylianos, the floor is yours, and I will unshare my screen in case you've got something to share with us. Thank you.
So, good afternoon, everybody. I hope you can hear me and you can also see the screen well. I would like, thank you very much. I would like to thank UCLan Cyprus and Stéphanie for running this seminar for a third year. Obviously, this was aimed to take place back in January to celebrate the Data Privacy Day. However, with the COVID era, nothing is certain anymore. Therefore, here we are, 2 months later, yet to discuss this quite important issue. You mentioned, Stephanie, that it was a pleasure to have us. Me and Maria, to be honest, it is our pleasure to be with you and thank you for trusting our knowledge on this important issue. Now, practical approach on data privacy. First of all, it is very, very important to realize what data privacy is all about. Back in 2018, when on the 28th of May 2018, the GDPR was going to be enforced across Europe, everybody thought that it would be like the virus of year 2000. For those of you who were at an age back then, everybody thought that on the 1st of January of 2000, something would have happened. Nothing happened, obviously. And with the GDPR on the 28th of May, again, nothing happened. The only thing that changed is that what is data protection? And there are a few pillars on this answer. The first pillar, and the most important pillar, is that data protection relates to the protection of the information of the individuals, which is a human right. So we're talking about the protection of a human right. The second pillar relates to the obligation of the enterprises to protect those data. Why they have to protect those data? They had to protect it before 2018, of course, but now why they have to exercise more protection, which takes me to third pillar, which is digitalization. Now, what's digitalization? Digitalization is what we're going through. If you look around, you will realize that everything is performed in an electronic way. And let me give you a few examples to compare what is the electronic way, which is the digital, and the non-digital. For example, a few years before, maybe a lot of years before, we used to send letters. For a few years now, we send emails. The email is the digital format of the letter. We used to take pictures with the cameras and take the film to the photographer to develop it. We have been using digital cameras for some years now, and now we take pictures with our phones, which are in electronic format in the sense that they're not paper, and we keep them in our phone stored or stored on a cloud service provider as in an electronic format. And if we want to share those data, we do share those data through the applications that are available. So in essence, nothing is in your hands anymore. Everything is somewhere in electronic format on a server or on a cloud. Now, this is the digitalization. You can also experience digitalization in your everyday life from some very simple examples that I will give you, which are: you were vaccinated and you wanted to prove the vaccination and that you have a safe pass. So what did you do? You downloaded the COVID application, and you registered, and then you got the QR, which you show whenever somebody needs to scan your phone. During COVID, you wanted to order, and you had these platforms, the usual platforms that you are familiar with, that you could register and then order your food, and they would deliver it to you. You make your transfers, your money transfers, you pay your bills through the platform of your bank. You order even not only your food, but your pet's food through a relevant platform, which also keeps the data of your pet as well. Now, all these are examples of the digital life we're going through. Obviously, now you're going to tell me, okay, where do the lawyers come into that? Well, I'm not going to give you the cliche answer that lawyers are everywhere and for everything, but I'm going to tell you that since these platforms process personal data, it means that they fall under the GDPR, which is a law, regulation, and passed as a law in Cyprus and all over Europe. So in essence, nowadays, what the enterprises need to do is to realize that they need to implement a system of protection of personal data in order to comply with the GDPR. If they don't do that, they face the threat that they would be fined by the Commissioner for the Protection of Personal Data. And mind you, all the decisions of the Commissioner are published on the website. So apart from the monetary damage, which is the penalty, they will also suffer the fact that the defamatory damage as well. So nowadays, 2022, personal data, protection of personal data, is not what we thought back in 2018. Back then, a lot of people thought that, okay, I need to tick a box, or I need to sign or take a consent or something. That's not at all. Nowadays, it's protecting the data we collect as enterprises. That relates as lawyers as well. And at the same time, where the lawyers come in is to advise their clients as to how to implement the correct system for the protection of personal data. A lot of enterprises, as a result of this, of the digitalization, they enter into the so-called digital transformation strategy. So what is a digital transformation strategy? It is the decision that every enterprise will take to convert from paper to digital. Now, this takes effort. This also, apart from effort, takes skills, knowledge, needs advice, and the most important thing, it needs to create the correct culture for the data protection. Why is that? Because if you have everything digital, it means that you still need to securely process them. In other words, to use them and at the same time keeping them secure, just like we do with any kind of information, with any kind of data we had so far. But nowadays, if you keep something in a digital format rather than on a paper format, what changes is the way you have at your disposal in order to protect them. Basically, what changes is the methodology on how to protect this new kind of data, the digital. Hence the GDPR. So what one needs to think is, what is the technical measures and what is the organizational measures that I need to take as an enterprise in order to keep my data secure? And in order to answer this question, maybe you need to ask another question, which is, what kind of data, what kind of measures I need to take in order to keep my data safe. From whom? Who is the threat? So we need to identify also the threat. And the threat under digitalization is, first of all, the hacker. And mind you, the hacker is not just the star player of a sci-fi movie. It's a reality. They will hit on a daily basis, and I have examples to tell you. It is the employee who will, in bad faith, enter the system, the server, the cloud, in order to collect data. Let's say, for example, it's an employee who wrongfully and in bad faith gets access to the server and enters the data of the payroll of a company and decides to go through them in order to suffice his curiosity as to why he didn't get a raise or whether someone else got a higher raise. That is a data breach which is punishable both for the employee but also for the employer. Another kind of issue that relates to security are the emails. The emails and sending the wrong email usually is the most common mistake that is done by enterprises, which will again lead to a data breach. Why is that? Because let's stick to HR and payroll. If, for example, you are the payroll manager and you need to send the payroll to your accountants who are outside the enterprise, and you copy paste the payroll on an email. On that email, you want to send it to the payroll guy. The payroll guy's name is, let's say, Andreas. You press A. On Office, A. Once you press A, it will bring you the most common names used and send emails beginning with A. It may not be this Andreas, it may someone else called Anna, for example, and as a result, you don't realize it. You press send, the payroll goes to Anna instead of Andreas, which means that it's a data breach. Now, all these, and in essence, all these are called data security incidents. And this is exactly from what you as lawyers need to advise the enterprises to be aware of. Why? Because before GDPR, a loss was just a loss. It could cause issues, but it was just a loss. Now, a loss, it is a loss, but at the same time, is a punishable offense. Because if you have a data breach or a data security incident, anything that would deprive the enterprise either from having access to the data or from the data escaping the safety environment of the enterprise and going outside that to a third entity's environment, that data breach, that is called data breach, which, as I said, is punishable offense, and it will trigger most probably the investigation by the Office of the Commissioner of the Protection of Personal Data. One would ask, how would they know? And the answer is, you need to report it. The enterprise needs to report it within 72 hours from the time it has realized that there was a data breach. Once that has been informed, once the Office of the Commissioner has been informed, they most probably will initiate an audit, depending on the kind of data breach. Let me share with you an experience. If you recall, back in a year ago, 25th of March 2021, a Turkish hacker, attacked the Ministry of Defense. That hacker managed to gain access through an application the Ministry of Defense was using. As a result of the access the hacker managed to get, the hacker had access to personal data that were kept in that application of the Ministry of Defense. That hacking, before the GDPR, would be just hacking. Nowadays, it's not just hacking. That triggered an audit from the commissioner. So the commissioner entered the ministry and the related businesses, performed an audit on their systems to verify as to how those systems were operating, what kind of security measures they were using, and whether they had taken the adequate technical and organizational measures. Resulting of the audit, the commissioner issued a report.
Apologies, Styliane. Can the person who has his mic on and his camera on switch off, please? Because it's interfering with the speech. Marios. Thank you.
Thank you, Stephanie. So from that audit, the commissioner went back to the ministry and to the related companies. I say related companies because some of the applications that were affected were outsourced from private companies, and told them that I have made some findings, and I want you to, I'm sending you the findings, and I want to know your side of the story, and in order to persuade me as to why I should not fine you, or if I'm going to fine you with the lesser degree possible. It works like mitigating for an accused in a criminal case. And those findings were both of technical and legal nature. So the legal nature was that did the company and the ministry, did the companies and the ministry apply data retention policy? Which was the data retention policy? In other words, how long they kept the data? So they wanted to know, was there a data flow mapping or not? Did they provide for their employees to have signed a confidentiality agreement? Have they gone through training, the employees, or not? And that was part of the legal. The technical now were as follows. We realized that you did not perform a penetration test. And the company answered, we did perform a penetration test, which it used that methodology. And then the commissioner replied and said, yes, but that penetration test, I don't recognize it. I call it vulnerability test. For those who have IT knowledge, the vulnerability test is a lesser strength test than the penetration test. And they engaged into a discussion trying to persuade that they have taken the necessary, the adequate technical measures to protect the data. So I'm closing this because I guess time is running out, to share with you the very fact that nowadays enterprises are entering the digitalization era, or they have entered the digitalization era, and because they always want to become quicker and to offer the best service faster, they will use the digital tools that are available. These digital tools usually are the applications, the CRMs, and the clouds. Within those tools, there is always a role for the lawyer to do a legal vetting, because before they go through the platform, since the platform will be collecting personal data, it is for a lawyer and an IT person to make sure, to work together, to make sure that GDPR provisions are applied. Also, they have to make sure that security provisions are applied. And again, it's the lawyer's job and the IT security guy's job to work together in order to finalize to which are the adequate technical measures to take for that platform. And the adequacy criteria relates basically on what kind of data are collected, sensitive or not, the volume of data are collected, who are the data subjects, for example, are the employees, are the students, are the clients, and lastly, as to whether those data are kept in server, cloud, within EU or outside EU. That's all from me. Stephanie, I think I have covered my bullet points, and I'm happy to answer questions, if any, now or later.
Thank you, Stylianos. I think that you gave them a very, very thorough, clear, and easy to apply guide to what each legal and other professionals should have in mind when assessing risks in terms of data protection and complying. So thank you very much. I'm sure there'll be some questions because some aspects could be developed further. But without any further ado, I think we should indeed go to our next speaker and last speaker for today, but last but not least, who is Maria Raphael. Good
Hello,
evening,
Stéphanie.
Maria.
Hi.
And as we said before, Maria will be talking about international data transfers, compliance, and challenges. And there are quite a few things to say as well. Thank you, Maria.
Let's move on to analyze today's topic, which is international data transfers. It is the hottest topic, I must admit, amongst privacy professionals and in companies around the world that are serious with data protection and want to be in compliance. I am obliged to share some technical and tiring details in relation to this complicated matter. Stephanie, if I run out of time, please let me know.
Thank you, Maria, but we are well on time, so don't worry.
Okay, so the first questions to be answered, the basis is, what constitutes an international data transfer? So this was answered rather recently by the European Data Protection Board with its guidelines, which were finalized in November 2021. Of course, the necessity to prepare these guidelines emerged after the very well-known Schrems decision, which we'll analyze later, and the requirement for international data transfers to undergo an transfer impact assessment. So we need to identify what an international data transfer is in order to decide which kind of data transfers are covered under Chapter V of GDPR and for which we must take the appropriate safeguards and proceed with an assessment. The NDPP clarified that we need two actors to be involved in order for a data transfer to take place. First, obviously, we need to have the exporter. It may be a controller or processor. So this exporter, this organization, must be subject to the GDPR. This means that it may be an organization that it is established in the EU, or if it is not established in the EU, its processing for the transfer in question is related to the offering of services and goods to data subjects in the Union, or to the monitoring of their behavior, as long as this monitoring takes place in the Union. The NDPP guidelines on the territorial scope of the GDPR are of importance in order to be able to identify if the company is an exporter subject to the GDPR, and if the exporter, or to be more accurate, if the processing undertaken by the exporter is subject to the GDPR, which this means that I am obliged to comply with the relevant provisions. Secondly, I need to have an exporter, and I need to have an importer, a company in a third country to which these personal data are transferred to. This importer may be subject or not subject to the GDPR. The criterion is whether the importer is geographically based outside the Union. So, in order to have a transfer, it goes without saying that you need to have a transfer between two entities, between the exporter and the importer. So the exporter must be disclosing information to the data subjects, to the importer, information in relation to the data subjects. And this is the reason why the NDPP clarified that where personal data are disclosed directly by the data subjects. An example is I go into a clothing website and I give my details to a website operator in a third country to send some clothes to me, and I give this information to a third country controller. This is not considered a data transfer according to NDPP. So this means that relevant provisions do not apply. Also, we need to have separate controllers or processors in order to have a transfer. This means that if, for example, an employee of the controller travels to a third country and access the personal data of the company remotely, this does not constitute a data transfer. Another example given by the NDPP, and I must disagree on that one, the NDPP considers that there is a transfer if an EU processor sends personal data of non-EU residents back to the non-EEA controller. I really doubt if this is the case because the personal data of non-EU residents, when they were processed by the non-EEA controller, were not afforded protection based on the GDPR. So why would they be afforded protection when transferred back by an EU processor to the non-EEA controller? The whole conversation started by the Schrems decision of July 2020. Up until that time, everybody knew what the transfer provisions were. It was well known to everybody that in the absence of an EU Commission advocacy decision, recognizing that these third countries enjoys adequate protection similar to the one afforded to the GDPR, then the transfer can move on. And in the absence of such decision, you need to apply appropriate safeguards, which are the transfer tools provided in Article 46 of the GDPR. The most well-known of them is the standard contractual clauses. Most of the organizations, most of the exporters, disregarded that the whole rationale behind these international data transfer provisions is to indeed ensure that the personal data transferred are afforded equivalent level of protection as to the level of protection guaranteed in the European Union, in the Union. So there were some small letters in the GDPR that were disregarded by most companies. It's not sufficient to only sign the standard contractual clauses, which are the clauses that have been adopted by the EU Commission to have them signed by the exporter and the importer, and you must not feel relieved that this is adequate in relation to your obligations under the GDPR. You must still make sure that the personal data are afforded an equivalent level of protection as the EU level of protection, and that they're afforded enforceable data subject rights and effective legal rights. And this guy, Schrems, the privacy activist, achieved to overturn the Safe Harbor EU Adequacy Commission, which made the transfers between EU and US possible. And then after he achieved that and a new data transfer framework was in place, the Privacy Shield, which was considered by the EU Commission to be enough for the companies to adhere to the principles of this Privacy Shield in order to showcase that the personal data are offered adequate level of protection. Then he moved on and targeted this new framework, the Privacy Shield. And the results were that the validity of the standard contractual clauses which were in place under the EU directive, their validity was questioned, but ultimately they were upheld. The question was whether the EU Commission, when adopting these standard contractual clauses, did the right thing, because these standard contractual clauses only bind the contracting parties, but do not bind the public authorities in third countries who may have access to the data. The European Court of Justice said that no, this is not the case. And it went on and assessed the Privacy Shield EU Commission, and it rendered it invalid, the decision of the EU Commission to by which it assessed the level of protection afforded by EU's data protection law, and whether the surveillance laws in the US were such as to provide limitations as to whether any measures are proportionate and necessary in a democratic society, and whether they offered remedies to the data subjects. And it ultimately rendered this decision invalid, noting that the three surveillance laws in question, the FISA 702, the Executive Order 12333, and the Presidential Policy Directive 28, do not give such safeguards, noting also that the ombudsperson that is provisioned in the Privacy Shield is not equivalent to a tribunal, an impartial and independent tribunal under Article 47 of the Charter. What the European Court of Justice did was to assess the surveillance laws by looking into the rights of the EU Charter of Fundamental Rights. So with the Privacy Shield invalidated, the question was how to transfer personal data to third countries in the absence of this framework. with the standard contractual clauses upheld, the result was to be able to use the standard contractual clauses for transfers to US, but not only to US, but to third countries as well. But at the same time, because the standard contractual clauses only bind the importer and the exporter, but not the public authorities in third countries to gain access to the data, signing of standard contractual clauses is not enough, and you need to assess your specific transfer to see if the laws and practice in the third country allow the exporter to comply and the importer to comply with the GDPR obligations that are given to the importer by virtue of the standard contractual clauses. So you need to assess the law and practice of the third country. And if you decide that the legislation is problematic, the practice is problematic, and that appropriate safeguards cannot be provided, then you must ask yourself whether, if adopting supplementary measures in addition to the standard contractual clauses, will be enough to ensure compliance with the EU level of protection. If not, you're required to either suspend or end the data transfer. After the issue of the Schrems decision, 1 or 2 months after that, Schrems, through its non-profit organization NOIB, filed 101 complaints against website operators that were continuing to send website visitor data to Google LLC and Facebook. And also, some months after that, file a complaint against the EU Parliament for the same reasons. So there was a series of decisions issued by the data protection authorities and a decision issued by the European Parliament in relation to this issue. And the result the assessment was that personal data identifiers of the visitors were sent to the US by Google. And despite that, Google had adopted supplementary measures. These supplementary measures were not enough to exclude the accessibility of this data to the EU's US intelligence services. Obviously, this development of invalidating the Privacy Shield framework and also be required to assess the legislation and practice of third countries, and at the same time for the exporter to be in an obligation to assess whether big tech companies and cloud service providers were adopting the necessary supplementary measures to protect the data, caused a lot of trouble to a lot of big US companies. Google had enough of it and made an announcement that despite the Schrems decision, the reality is that for 15 years we're using the analytic services. Never did Google receive any time of request of access by the US intelligence information services. So it pushed for the finalization of a successor agreement, an agreement that would replace the Privacy Shield as soon as possible. And then Meta in its annual report of 2021 said that the data protection requirements, the validation of the data transfer framework, the risks involved in being subject to enforcement proceedings by the data protection authorities, etc., jeopardizes our ability to offer services in Europe. So if this continues and another framework is not adopted, then we're maybe not in a position to offer a number of our services in Europe. And what was the reaction of the US government? They, in the aftermath of the Schrems decision, they sat down and tried to identify some possible solutions to the issue. The Congress discussed whether it was a possible option to issue or amend the executive orders in place to provide additional redress mechanisms in addition to the redress mechanisms that were in place. Was it a solution to adopt another privacy shield kind framework or adopt a treaty with the EU? Or should I address this by legislation to prohibit bulk intelligence collections and for a court approval to be required for each target or surveillance and to provide actionable data subject rights? So these were the solutions discussed. On the other hand, what the US government tried to show was that the Schrems decision was not a decision that it assessed negatively and comprehensively the data protection framework and whether the surveillance laws and the US law afforded adequate protection. It only assessed the validity of the EU Commission of the decision of the EU Commission by which it assessed this framework. And it tried to showcase by a White House white paper that most of the companies, and I believe that this is the reality by reading the relevant US surveillance laws, do not transfer any personal data that are of any interest to the US intelligence agencies. So most of the transfers do not fall under the scope of the US surveillance laws. And most of the cases where personal data of EU persons were processed and accessed, it was related to cases that served the EU public interests and involved operatives and plots in foreign countries. So with the reasoning that the overwhelming majority of companies have never received orders to disclose data under the FISA, the surveillance law, and at the same time, most companies do not transfer any intelligence information that may be of relevance and importance to the EU's US intelligence agents. The White House tried to showcase that the exporters, when trying to conduct their transfer impact assessments, they may safely conclude that in most cases there is no issue and the transfer can go on. After intense negotiations between the EU and the US, very recently, some days ago, there was an agreement in principle between the US and the EU. They have agreed on 5 key principles, which on the face of it seems to satisfy the GDPR requirements and the requirements of the EU Charter of Fundamental Rights. So the government of the US government was committed to provide rules for a necessary and proportionate access to personal data, to establish a data protection review court and to offer an effective oversight of new privacy and civil liability standards, and also for companies to still be able to self-certify under the privacy shield principles. So on the face of it, they covered the gaps. But there were some reactions in relation to the fact that the US government chose to address those issues by way of EU-US executive order rather than by law. We will discuss this later on. So what are the next steps? This framework must be included into legal documentation. The EU Commission must make a proposal for an adequacy assessment. An EU Commission adequacy assessment will be required, followed by an NDPP opinion and an approval of the representatives of EU countries, and possibly, if all goes well, to the adoption of an EU Commission relevant to this framework. And Schrems. Schrems' first reaction was to react negatively on the announcement of this framework, and he only saw a political analysis and a political announcement which did not have any legal consequences, which is true, because the political announcement itself does nothing to help the companies at the moment to help with the data transfers to the US. And it pointed out that the US foreseen executive reassurances may not be enough to meet the test of the European Court of Justice, and he says that they may challenge the decision again before the court. So there may be a Schrems 3 around the corner. And the question is whether an executive order can save the day. An executive order in the US is issued by the president, the US president. Despite that, it is not legislation per se. The executive orders do have the force and effect of federal law. They derive their power by the Constitution, by the Congress, the legislation, and the inherent authority. They can be overturned by the sitting president, by the court, but only if the president acted outside of his authority, which is rather a rare occasion, and where the Congress, via legislation, expressly overturned the executive order or eliminated funding. This again may be a rare occasion, because it will most probably encounter a presidential veto, for which can be overridden only by a 2/3 majority of the Congress. Yes, if you look into the relevant articles of the EU Charter of the Fundamental Rights, there is a right to an effective remedy before an impartial tribunal established by the law. The executive order may not be a law, but it has the force of a law. And any limitation of any EU Charter right must be provided by the law itself. So the main question will be, are the executive orders law? Can they be interpreted as such? And I'm not sure if there will be an issue in relation to this, because by reading the European Court of Justice decision, you can see that the European Court of Justice, when looking into the executive order and the policy presidential directive, it tried to verify if they offer a right to an effective remedy, if they abide by the proportionality principle. So it looked into them. It did not comment that these are executive orders and they can't provide such safeguards, so I will not look into them. So it remains to be seen how the situation will unfold in the future and how the law will be interpreted. At the time being, we need to still be signing the new standard contractual clauses that were issued by the EU Commission. They were adopted in June 2021. They provide two additional sets of standard contractual clauses, processor to processor standard contractual clauses and processor to controller, which were not there before. And the deadline to replace the old standard contractual clauses, which were effective and enforced under the directive, has already elapsed. It was the 27th of December. It is important to note that these standard contractual clauses also incorporate provisions relevant to Article 28(3) of the GDPR, which relate to the relationship between the controller and the processor. As a matter of fact, the EU Commission has issued another set of standard contractual clauses to govern the relationship between controllers and processors in the EU and EEA, but only in relation to the requirements of Article 22. So if you have an agreement with a processor and you will transfer data to them, signing only to third countries, signing the standard contractual clauses may be enough to cover to a very large extent the obligations of a data processing agreement under Article 28 of the GDPR. This is the overall structure of the new sets of the standard contractual clauses. We have some general clauses that are applicable in relation to all modules, whether the relationship is one of controller to processor to controller. This means that you have to identify those, what is the exact relationship between the exporter and importer in order to choose the appropriate module, because if you go to other sections, the second section of the GDPR, the approach is modular. So there are clauses, there are different wordings in relation to each module. Section number 3 is also applicable in relation to all modules and provides and gives obligations to the data importer in relation to giving access to personal data to third country public authorities and challenging any disclosure order that may be issued after assessing it and concluding that there are enough legal grounds to successfully challenge that order, and also an obligation of the importer to inform the exporter that there is a data disclosure request. Section 4, there are some terms there in relation to non-compliance and termination, the governing law to be chosen by the parties. A good point to make is that this governing law must grant third-party beneficiary rights, which is not the case with Cyprus law. And this is something that we have brought into the attention of the Commissioner, and it seems that she intends to propose relevant amendments to the law in order to grant such rights, and for the Cyprus law to be able to be chosen in standard contractual clauses. So you need to choose which are your which is the applicable module depending on the relationship, and complete the annexes. Annex 1, which are the parties, describe the transfer, identify the competent supervisory authority, and in Annex 2, give a list and describe in some detail the technical organizational measures that will be taken for the transfer, including security measures. And this annex must also provide, if you will use a sub-processor, if the processor will use a sub-processor, even if my agreement, I am the controller and I have an agreement with a processor, and this processor engaged a sub-processor, the controller must know beforehand what measures will be taken by the sub-processor engaged by the processor to protect the personal data, and refer to this in the annex. And then you must provide a list of your sub-processors if the sub-processors have been identified after a specific authorization by the controller. There are a lot of practical issues in relation to the standard contractual clauses. A big gap is that we do not have standard contractual clauses to cover transfers to third country importers that are subject to GDPR under Article 3.2, which is the article which renders companies which are established outside of the EU subject to the GDPR if they offer goods and services to data subjects in the EU, or if they monitor their behavior. There is a recital in the EU Commission implementing decision that says that the current standard contractual clauses only cover transfers to third country importers that are not subject to the GDPR. But if we recall what we have discussed earlier, the NDPP clarified that the importer may be an entity that may be subject to the GDPR. So we do not have standard contractual clauses in place. The NDPP, with its latest guidelines, noticed this, as well as the EU Commission already observed it, and said that I am ready to help the Commission to develop such standard contractual clauses. So what happens in the meantime, in the absence of these standard contractual clauses? In my opinion, because the recital of the implementing decision is not binding law, and the standard contractual clauses themselves say that the standard contractual clauses provide appropriate safeguards for transfers to third country importers that are not subject to GDPR. It goes without saying that this means that they may also provide appropriate safeguards for transfers to importers that are already subject to GDPR, and they already have this GDPR obligation based derived from law alone. The result would be that standard contractual clauses may be repetitive, may repeat GDPR obligations that the importer that is subject to the GDPR already has. There are several other issues, but I don't want to tire you with. You need to be careful when you also have a data processing agreement under Article 28 with your processor, because there are some gaps and some issues that are not covered by the SCCs for the international data transfers that you may need to include in the standard contractual clauses. For example, for the processor's obligation to provide assistance to the DPIAs and provide assistance with controllers' own security measures. In general, you are allowed to add clauses to the standard contractual clauses, and on a wider contract or separate clauses, but you need to make sure that they do not contradict directly or indirectly the level of protection of personal data that are provided with the standard contractual clauses. These are some practical and difficult issues to be addressed by the exporters and the importers. You need to identify which is your competent supervisory authority as stated in the annex. This is not usually an easy exercise. And it seems that you need to be as specific as possible when completing Annex 2 and give as much more detailed information in relation to the measures that will be taken to assure the effectiveness of the supplementary measures. INDPB has issued guidelines on what kind of supplementary measures can be taken to ensure compliance with the EU level of protection of personal data. Generally, the guidelines takes you from start to finish on what you must do in order to make sure that you transfer personal data to third countries in compliance with the GDPR. First of all, it's you need to know your transfers. Proceed with recording and mapping all your transfers to third countries, including on-work transfers. This means that if I am a controller and I engage a processor, and this processor engages a sub-processor, I must be in a position to include this in my ROPA. And where I identify that personal data are left and are traveled outside the Union, I need to see and to decide which will be my transfer tool. Is there an adequacy decision? Can I rely on the derogations? If not, and I want to transfer data to a third country that does not enjoy an EU Commission adequacy decision, and I possibly want to use the SECs, then I need to assess the effectiveness of the transfer tool. So the question is, if I sign the SCCs, is the law and practice of the third country such that can safeguard that the safeguards that are taken under the SCCs can be implemented in the third country? Is there anything in the third country or law that may not allow the importer to comply with the obligations under the standard contractual clauses? Stephanie, I'm running out of time. How much time do I have left?
I mean, this is fascinating, so that's why I haven't stopped it. And
how much time do I have?
I'm sure that everybody is benefiting from it. I was just wondering if Stylianos could also put his camera on. Maria stayed with us as well, and maybe we open the floor to questions.
I only have 3 slides. I can go over them very quickly.
Okay, yeah, because we have to finish in 10 minutes. So
okay, we will finish in some minutes. And then if the answer is that no appropriate safeguards can be taken with the SSEs alone, then you need to decide whether you need to adopt supplementary measures, whether contractual, technical, or organizational. And if these supplementary measures do provide sufficient guarantees, move on and adopt your transfer tool, and then reassess at appropriate intervals the legality of the transfers. The NDPP categorized between 3 types of supplementary measures: technical, contractual, and organizational. I will stick to the technical measures because I'm cautious of the time. So the key, the information to hold out of these guidelines is that transit encryption and encryption for data addressed is not enough if the importer needs to have access to data in the clear in order to provide its services. When the importer is a cloud infrastructure service provider, this isn't an issue because you don't need decrypted data in order to provide the service. But in most of the cases of services provided by a processor, then you need to have access to data in the clear. So the importer needs to hold the cryptographic keys. They can decrypt the information, and this is an issue that the NDPP could not address. There are some upcoming developments in this area of law. The NDPP issued codes of guidelines for adopting codes of contact for international data transfers. This is an alternative transfer mechanism. We may see certifications in the future as a voluntary accountability tool for international data transfers, the new SCCs that are coming. And also there is a proposed Data Act by the EU Commission of February, where the Article 27 expressly says and provisions restrictions on international transfer and government access to non-personal data, not only personal data. That's all. How much time did it take?
Thank you so much, Maria.
Thank you.
Long enough.
How long?
But about 40 minutes, but that was extremely helpful. Participants to the webinar have been asking for your slides, both of you. Is it possible to share the slides with the participants to the webinar?
Yes, of course. It will be a pleasure.
Thank you very much. So we will upload them to the MS Teams as soon as Stylianos and Maria actually send them to us. So thank you for this. I have a billion questions, obviously, so, you know, I'm not going to monopolize the discussion. Let's see if there is anything in the chat that would need to be... Yes, there is a question about the choice of law. Let's see if there is anything else. So far, nothing. The problem is that we have covered so much that I'm not even sure at what point the question was asked, which was on choice of law, Rome 1 regulation. Will it apply to these contractual obligations? I suspect it refers to what Maria was talking about, but at what point I'm not so sure.
Maybe the question is related to the governing law of the standard contractual clauses.
Could be, yes, or obviously the you know, the choice of jurisdiction as well.
You are required under the standard contractual clauses to state the forum of the jurisdiction. So you need to state this in the standard contractual clauses, as well as also provide for the governing law.
Thank you, Maria. There is one more question here. It's a long one. Oh, no, okay, I missed it. So, other than thanking the presenters, the question reads as follows. As a data subject, if data consented to and given to a service provider A, that is a member of a parent company, does this give the permission to the parent company and or its subsidiaries to use that data, or the consent given is fixated specifically to the service provider A? It is known that they, the service providers, are allowed to include that expressly on the license provided, but by default, what does the law on GDPR has to say about it? Is there an implied permission to the process of that data between subsidiaries by default or otherwise? Interesting.
Yeah, indeed. Can I have a go?
Yes,
of course.
go on.
I have to say that I've read the question while Maria was finishing her presentation, so maybe I am a bit more prepared. Okay, two sections to the answer of this question. First of all, we have to remind ourselves of the basic rules of processing personal data as per the GDPR. Every enterprise, or if I want to be more technical, every controller has to collect the necessary data and use them only for the purpose it has collected them for. So, Nicolas, when service provider A has collected data, he must have collected them for a particular purpose. So must use them only for that purpose. It is rare for a subsidiary to use the data and pass them to the mother company, as you say in your example. And this is usually a rather common mistake that is done among a group of companies. They think, and we have to persuade them to the opposite, that they can pass on data from one another just because they are of the same group or they are related. The main rule is you use the data only for the purpose you have collected them for. The second part of the answer that I have to give, which is not, it may not derive from your question, you refer to consent. We have to clarify. GDPR has changed the scope of the consent. Prior to GDPR, for any enterprise to process data, they had to have sort of consent. GDPR onwards, this has changed. If an enterprise needs to process data in order, for example, to perform the service the data subject has requested, or in order to abide with a legal principle, or to protect its legitimate interests, and so on, they can do that without consent, but still under the main rule that they will only use the data for the purpose they have collected them for. And I hope the answer clarifies.
If I may add on this, if the transfer of personal data to the service provider is an international data transfer, this complicates things because consent is a derogation. And as such, it can only be applied rarely to justify an international data transfer. Only for a small amount of data, if the data transfers are not repetitive and cellular, which is rarely the case. And even if we assume that the data were transferred to the service provider, a processor in a third country, and consent was not the basis, but standard contractual clauses were the basis. This does not give permission itself to the parent company or its subsidiaries to use that data, except if there is an authorization by the controller and processor and the controller of the data, and the controller knows beforehand of the processor's intention to transfer the personal data to another entity.
Thank you both. And this is you know, very tricky, because obviously data travel faster than even the way we can even think about them. So your two answers, you know, of the same coin give, you know, the full picture. Thank you so much. Let me have a look at whether there is something else. There isn't. Is there, because we do have a lot of participants here, is there someone who would like to grasp the last chance of asking a question? Or are we all desperate to go on long weekend, which could be fair enough, after 1.5 hours of data protection? No? I mean, I am very interested in, you know, what's going to unfold. As both of you have, you know, identified some of the issues that are going to arise, whether they're in terms of policy making, lawmaking, or even business assessments or risk assessments. So I think that, you know, this is only part one. I think we should return in a few months' time to actually evaluate where we stand, because things are very dependent on changes, world changes, global changes. And as Maria was just, you know, illustrating by looking, you know, at the last meeting between President Biden and President von der Leyen, you know, politics also interfere or influence the way lawmaking is actually developing. And there is a huge range of acts that are currently pending at the EU level. The Data Act is one, of course, but there is the AI Act, and there is the Digital Markets Act, and there's the Digital Services Act. I mean, there are so many different acts, and these are actually intertwined with each other. And the relationship of those forthcoming acts, one of which was adopted last week, by the way, the Data Services Act, the Digital Services Act, together with the GDPR, is going to be a challenge for legal professionals to apply and to find their way. I mean, GDPR is difficult enough to navigate, but we are going to have an increasing range of EU acts and EU legislation to deal with. So I would like to thank you both very, very much for the time you have devoted to us, for the preparation and for the discussion. I'm happy to give you the floor to close, to both of you. Any last thoughts?
Thank you, Stephanie. Before we close, there is a question,
There's one more question.
From a colleague. Maybe it's only fair to address it. It says that how will you ensure that you are transparent with your client when your privacy policy must cover your entities, some of which are in third countries and will be covered by SCCC? Maybe it falls under Maria's spectrum, but I could just say that the privacy policy is the document that, under the GDPR, has to provide the information as to how the data are processed. Therefore, that's the document where transparently you need to refer to and say at a particular section, which should be headed that where we transfer your data, highlight the third countries and explain why. and in occasion you have to also take the relevant consent. But I will also let Maria elaborate further since it's her area.
Trying to understand the question, whether you're transparent with your client when your privacy policy must cover your entities, some of which are in third countries and will be covered by the standard contractual clauses. If the transparency here is related to the information provided to the data subjects, then yes, this is accomplished via the privacy notice provided to the data subjects. You don't need to name the entities in the privacy notice. It may be enough to refer to the categories of entities to which you transfer personal data. So this is the way to do it. If you're a processor and you're a cloud service provider and your client is a controller, you still need to be transparent as to the sub-processors you intend to engage, and give this information in a transparent way to this client, which is your controller. And a screening must take place of whether these sub-processors adopt the adequate measures, and why this is necessary. In order for the controller to be able to assess if the personal data that will be transferred to the processor, and then after that to a sub-processor, will be afforded an equivalent level of protection. So if not enough information is provided, the screening of the processors and the sub-processors cannot take place. So the assessment, which forms part of the international data transfer exercise, cannot take place. So you cannot, if this does not take place, it's not reasonable to choose the specific processor to provide to engage with. So it's wise and it benefits the processor to have this information already in hand and provide them to the client, and basically give the solution to the client. Give already a big part of the assessment that the exporter is required to do under the law.
Thanks a lot. I think this is, the last word, conclusion word. As I said, I think this should be part A. Let's return in some months with part B. To the 60 plus participants to this webinar, could I please ask you to give us feedback on this webinar, and particularly the topic, whether you would like to see more of this topic, for example, and in that case, which sort of topics, of subtopics, because we have touched upon a lot of issues. That would be very helpful for us. Nicolas has kindly placed in the chat the link to the feedback form. If I could please ask you to, spare a few moments to actually give us feedback, because this is how we actually make sure that we address the needs of the legal profession. So I'd like to thank everyone for your time and for your efforts. And I would like to wish you a good long weekend, well deserved for all of us. And I hope you stay away from COVID as well. Take care, everyone. And we will be soon back. This video will also be available on our website quite soon, and you'll be able to view it in the MS Teams. In the meantime, please feel free to utilize this. Thank you so much. Thank you both. See you soon.
See you.
Take care.
Bye.
Thank you very much.
Bye,
Thank
everyone.
you,
Bye.
Enjoy, everybody. Bye-bye.
Bye.